of the appeals court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning. Welcome to the appeals court. I'm Justice Meade. To my right is Justice Ditkoff, and to my left is Justice Hershfang. We will be the panel for the cases this morning. Each side gets 15 minutes. You needn't use all of your time. We do not entertain rebuttal. We have read everything. It's my best suggestion that you get right to the point. With that, I'll call our first case, 24P 699 Commonwealth versus Fagan. Mr. Goldwyn.
Thank you, Your Honors. Stephen Goldwyn with the honor and pleasure to represent the Fagans in this case. I think the primary crux of the argument is that the Commonwealth did not prove, no reasonable trier of fact could find beyond a reasonable doubt that the Commonwealth proved that either the defendant had the intent to put the alleged victim in imminent fear of a battery, nor that the reasonable victim could apprehend as such. There are three separate and distinct reasons I would argue as such. Number one, in this day and age of social media and news and glamour, we hear more often than it seems we used to of road rage shootings or plane crashes going down or school shootings and the rest of it. We don't hear about the airplane that took off at Logan and landed safely.
Mr. Goldwyn, let's stick to the facts in this case.
In this case, the point being that this was a road rage, glorified road rage incident. I would suggest that 99.99% of the time, maybe I'm biting off more than I either can or need to chew, a road rage incident does not end with a killing or a shooting. It ends with a swear finger, it ends with a rolling of the eyes, maybe a swear word, and people go along their way. The point being that neither the intent nor the reasonable perception that somebody aiming a gun would actually kill somebody or batter somebody, and that's a reasonable perception.
Well, it's reasonable apprehension of harm, right?
Right.
And so that means it's an objective standard.
Right.
And he pointed the gun at him and twice said, "I'm going to fucking kill you."
Right.
Why wouldn't it be reasonable to conclude that a person under those circumstances would apprehend immediate harm?
Well, that's my first of 3 points. That one, 99 times out of 100, at 3 o'clock in the afternoon with people all around in a gas station with surveillance over not somebody coming at you with a gun because it's a father mad at somebody for raping their daughter, not because somebody murdered their son, but because they had a road rage incident. It's not reasonable to think that that person is actually going to pull the trigger under those circumstances.
He doesn't actually have to pull the trigger.
It's not right, but he has to be in fear that he will.
And twice promised to shoot him.
Right. But again,
let me ask you this: Is it inferences to be drawn from the evidence only need to be reasonable and possible? So why isn't that a possible inference to be drawn from having a gun pointing in one's face and being twice told that he was going to fucking shoot him?
Well, I don't know if possible is good enough. It does have to be a reasonable inference, and I'd suggest, again, I'll get to my other 2 points, but the first point is it's not reasonable to feel as an objective standard that under those circumstances, not only just what happened, but where you are, that someone is actually going to pull the trigger. You compound that.
I just want to make sure I'm following. So your position is that a reasonable person looking down the barrel of a gun that is, some small number of yards away would go through the calculus in their head, well, it's 3 o'clock, I'm in a gas station, this is a road rage incident, those don't often end in a gunshot wound to the head, so I'm not afraid.
It wouldn't be that, it would be more subconscious. It wouldn't be that take out a calculator and a PowerPoint program and go through the analysis. But yes, that if you're in a minor, I'll call it, road rage incident, again, this isn't medium to heavy type stuff, like somebody just raped my daughter, somebody murdered my baby, somebody just beat the living hell out of somebody. You got in a everyday run-of-the-mill road rage incident, you're in broad daylight, this guy's not shooting me, yes.
Well, in the everyday run-of-the-mill road rage incident, is it normal for someone to pull out a weapon?
No.
So we're already kind of out of that regular
Right.
situation.
Correct. And again, I want to get to, I think, as important, points 2 and 3, coupled with that first point, is the verbiage. I will. And I think that language, and again, we're not talking possibilities, we're talking a reasonable inference of what that language means, has to mean, a reasonable inference of, and an interpretation of that has to mean contingency and future. It's not meet your maker. It's not you're dead. It's not I am killing you presently.
Wouldn't I would be a contingency?
If it was,
I mean, it's
I
the
would kill you.
conjunctive. You know, I would suggesting an if, I will suggest an unconditional, doesn't it? I mean, grammatically.
I think that's semantical. I would agree that would is more English language contingency, but I will is clearly different than I am. Will is future.
I mean, it's sort of a funny thing about English, right? That we never actually use the present tense in that situation. So the present tense would be I kill you. That's just weird English, right? So what we say as native English speakers is I'll kill you or I'm killing you, the present progressive. But I think I will, it could mean the future, for sure, right? Do you want to have lunch? Yeah, let's do that. Okay, I'll see you next Thursday. That's the future, right? At the same time, it could be a very immediate future. Oh, I forgot to get some sugar for my coffee. Oh, I'll get that for you. That's future like 2 seconds from now. So, which I think is pretty imminent, right?
Yep. I agree with you. Nobody's going to say, as we speak, I am killing you now. That wouldn't be normal. But it would be, you're dead, you're going down, you're paying for what you're doing. There's about, and I could probably go on to name 50 expressions that one can use, or use no expression.
Well, I mean, you took issue with Justice Ditkoff being semantical, and I think the words that must be measured by a reasonable person standard, not one with the acumen, the grammatical acumen of an Oxford Don. So think about this reasonably. I'm going to fucking shoot you when he's pointing a gun at his face. Did you want to talk about your second issue?
Well, I am. No, he said, I will. If he says, I'm going to, I guess that's another semantical analysis. But I thought the verbiage was, I will kill you.
It's I'll fucking shoot you, according
right.
to the briefing.
I'll fucking kill you, right. I would suggest that A, coupled with the first argument, but B, the verbiage, it needs to imply either future and or contingency. And really, we have, not to pardon the pun, the smoking gun of what a reasonable person would do or react is we have what they did. This person who lived it, we don't have to conjecture about what would a reasonable person in that situation, how would they perceive it, how would they react? We have somebody in that situation, the alleged victim, how did they react to this perceived present, future conditional threat? Did not duck, did not scream, did not floor it and get out of there.
But didn't he stare into your client's eyes to try to determine whether he was going to shoot him?
Yes.
And doesn't that suggest that he was apprehending harm?
No, he was, I think, doing the calculus Judge Hershfang in a different way. He was in disbelief, I think the word was, like, wow, this is strange. I don't believe this is happening. And then after that calculus, what he came up with is, you're a fucking pussy. Meaning, what are we talking about here? The only real reasonable inference with the verbiage, the circumstances, and how we've seen the victim react is this was a, let's slow your roll, let's end this, let's calm this down. If you escalate, if you continue to do this, there's going to be trouble. That is truly the only explanation, not only from the defendant, but from the perception of the alleged victim, what was going on. Further, the second stage of the argument is the ineffective assistance of counsel.
Well, that's interesting. So if you point a gun at someone and said, I'll shoot you if you don't back down, that wouldn't be an assault?
I don't think so. I think that's a threat to commit a crime. Because that's not an imminent, it's not a threat of an imminent battery, it's a threat of a potential future battery. The literal, exact, essentially definition of a threat, and I would suggest the exact 180 degrees from what's required of a threat of an immediate battery. And even, I do understand that the subjectivity is not the analysis of the victim, but I think it certainly lends credence to the objectivity, that what would a reasonable person think? If you look at the Commonwealth's, even the Commonwealth's brief, in Commonwealth versus Gordon, in criminal assault cases, courts look to the actions and the words of the defendant in light of the attendant circumstances to determine whether the victim's apprehension was reasonable. In this case, I would suggest, A, he wasn't in fear subjectively, and B, if the court disagrees and he was, it wouldn't be reasonable under the circumstances. And I didn't brief this. It came to my mind while thinking of this argument. Defense counsel, I believe, was ineffective in two separate ways. One, this argument may ultimately fail to your honors. But this argument was not even made to the trial judge. The only argument made was self-defense. This argument that I'm bringing forward to your honors had a chance, if not now, with a different standard.
This is not in your brief.
It is not in my brief.
Yeah, so it's waived.
All right. Then the last aspect of the ineffective is this is a man with 0.0 criminal record. He had a job of 16 years, works for the state. If you, as it turns out, have a guilty of a misdemeanor, you keep your job. If you have a guilty of a felony, you lose your job. This had to be explored, where my client is stated under oath, and I think it's not just self-serving, it makes sense if given the opportunity and the option to come to the district attorney and say, hey, look, this guy's got no record, there was no injury, arguably not even harm.
You don't have a record that supports that there was any deal on the table. You don't have an affidavit from trial counsel. You don't have an affidavit from the assistant district attorney. There's the cases where this comes into play is when there was an offer on the table and it was not brought to the defendant's attention. You don't have that.
I don't. It didn't exist.
You have supposition.
Right. And all it would take, which I would require, is a hearing. If there's a hearing with the district...
Without something more than a supposition, you don't have a substantial issue which gets you a hearing.
The defendant was deprived of a clear, obvious opportunity, which you don't know what you don't know. I did speak, and I don't want to go off record, but I did speak at great length with defense counsel. There was no offer on the table. He didn't request an offer on the table. I did try to speak to the district attorney, got nowhere. What other avenue would I have but to request in the lower court a hearing on this matter? I'm asking you to find that that was unreasonable or wrong of the lower court judge to not give me that potential evidence to bring then potentially to this court. I would have no way.
Why couldn't you go and have some people who practice in that court say, under these circumstances, often there's a breakdown to assault when it's a road rage with someone pointing a gun? I mean, I doubt that's the case. I mean, but if there was that evidence that there was a culture of that, couldn't you have gotten an affidavit saying, yeah, no, that's the kind of deal that happens all the time?
Meaning from defense or prosecutor or both?
Yeah, just lawyers who practice in that in Middlesex. You know, yeah, no, this is pretty common agreement in these kind of cases. If that exists, couldn't you have done that?
I suppose I could have. I don't know that that would be as persuasive as getting it from the only real source, which is the horse's mouth, which is to have a 3-minute hearing. Madam DA, if this was brought to your attention at that time, this man has no record, there was no injury, the victim wasn't even emotionally harmed by it.
We're going to have to leave it there, Mr. Goldwyn.
Thank
Your time
you.
is up.
Thank you, Your Honors.
Mr. Punch.
Good morning. May it please the Court. Assistant District Attorney Dylan Punch, on behalf of Middlesex County for the Commonwealth. The Commonwealth asks that this Court affirm the judgments and order of the Waltham District Court because there is ample evidence that the defendant committed assault by means of a dangerous weapon when he pointed a firearm directly at the victim's face and said, quote, "I'll fucking shoot you." And further, there is no information in the record that the defendant's trial counsel was ineffective or that the defendant was in any way prejudiced by counsel's performance. Now, here, the defendant is challenging the sufficiency of the evidence on 2 of the assault by means of dangerous weapons elements. As to the first one, whether or not he intended to place the victim in fear of an imminent battery, I don't believe it's necessary to get semantical. The fact that there was a firearm pointed directly at the victim's face kind of removes any of the temporal vagaries that we may have to worry about. And of course, so as far as I believe...
Attorney Punch, can I ask you a question about that? And this is a hypothetical, so you could dodge it if you would like. But to what extent do you think that the words matter in this case? In other words, if the defendant had simply pointed the gun straight at the victim's face in that interaction, in your understanding of the legal framework, would that still be an assault?
I would say yes, Your Honor. Having a firearm pointed directly at your face is fairly strong evidence that someone is imminently going to shoot you. And the standard for this is not fear, is not the victim's fear. His reaction certainly does show some level of bravado or machismo, but the standard is whether or not he perceived an imminent threat. And he testified. He said he was in disbelief at how the situation escalated. He said he was watching the defendant to see if the...
And you don't mention this in your brief, and it's kind of weird because it's a claim that was made at trial and on appeal with the victim embodying a level of temerity of which I'm not familiar with a gun pointed at him, at his face, called him a fucking pussy. And you don't mention that at all. Why doesn't that take care of the reasonable apprehension of harm?
Well, it is an objective standard, Your Honor, and it's whether or not he perceived the imminent threat. And here he said, I was waiting to see whether or not the defendant was going to shoot me. I mean, he clearly was aware that there was an imminent threat, and I can't necessarily speak to his state of mind, but his words show that he did, he had an apprehension that a threat may be incoming. Now, as to the second issue for the ineffective assistance of counsel, I think it's been pretty well fleshed out. There's just no evidence whether or not, apart from the defendant's affidavit saying he would have accepted a misdemeanor plea, there's no evidence that one was on the table. Whether or not the court would have approved it, we don't know what conversations or tactical decisions were made because we don't have these affidavits. So the motion for, a new trial was properly denied without a hearing because we didn't have any substantial issue in the papers.
It's okay if you don't know the answer to this, but do you know who the trial prosecutor was?
I do. Assistant District Attorney Anna, excuse the pronunciation, I believe it's Talon.
I'm sorry, just say it again.
Anna Talon, I believe is how you pronounce her last name, Your Honor.
All right, it's weird. I couldn't find it in the record. It just says the Commonwealth in the transcript, which is pretty unusual.
I had to do some digging, Your Honor. If there's no further questions, the Commonwealth rests on its brief.
I'm good. No, thank you. Thank you both. We'll take it under advisement. Our next case is 24P 1017, Department of Children and Families and another versus Father and another. I remind counsel that this case is impounded, so please refrain from using any names. Use descriptive titles or other appropriate indicators. He wants the CEO. I'm trying to figure out if he was the CEO. Ms. Dow.
Good morning. May it please the court, Attorney Deborah Dow for the father who is seated in the courtroom today. Every parent that walks into the courtroom of the juvenile court has an expectation that they will be heard and has a right to an adversarial process. The failure to allow any of father's witnesses to testify completely eliminated the adversarial process. When there is such an egregious breakdown of the adversarial process, the process is presumptively unreliable. Counsel for the child argued that father wasn't challenging any of the findings, but to the contrary, father was challenging the findings in total. Because the judge did not have full evidence, he only had half of the evidence. The judge was required to weigh all of the evidence, not just one side.
So I want, you say in your brief that the burden was on the department to show prejudice from the calling of the late disclosed witnesses. And I didn't see anything in Rule 15 that indicated to me that the department had that burden. What is the source, what is the legal principle that, or case or rule that you base that statement on?
So the department always has the burden in these cases. And I think once...
The burden of proof, right?
Burden of proof.
But I guess that doesn't necessarily, in my mind, I'm asking you to sort of, if that's where you're coming from, to give me the crumbs on the pathway to a legal principle that says that the burden of proof extends to proving prejudice if the father is allowed to call late disclosed witnesses.
So the reason why I state that is that once the father was able to say, you know, I need these witnesses, you know, everybody knew these witnesses. The first 23 witnesses on father's pretrial memo were the same as child's and department's. Once the father was able to articulate that there was prejudice to him in the form of due process, and he did make that argument, then the burden shifts.
Well, no, hold on. So where did he do that? Where did he demonstrate there was prejudice to him?
He argued that when the judge initially denied his ability to call the witnesses. He argued that on that date that the judge, I believe it was November 6th of 2023.
Well, but arguing that and demonstrating it aren't the same thing. What's the demonstration of prejudice from not being able to call these two witnesses?
Father was denied his ability to participate.
Well, no, he participated in the case. He testified for extensive amounts. So how is he prejudiced from not being able to call these two witnesses whose reports were in the record? Well,
the father was not able to, and I think it's, frankly, the Brantley case stands for that proposition. Fundamental fairness dictates that parents can rebut the evidence against them concerning their child-rearing capabilities. And once he suggested that there was a due process violation, and clearly there is, father had no ability to put on a case whatsoever. It wasn't as if one witness was excluded or two witnesses were excluded or even the testimony was limited. or, defined to rebuttal. It wasn't any of that. It was just wholesale exclusion.
So let me back up even further. His counsel was required to disclose to witnesses in the pretrial memorandum, right?
Correct.
And that was not filed.
It was filed late.
Right, and it was brought to his attention that it was late.
It was brought to his attention on the day that he first tried to call a witness.
And did he show good cause for why it was late?
I think he tried to show good cause. I don't know that the judge determined that there was good cause.
What was his attempt?
Well, the day of that he was denied the ability to call witnesses, he argued due process. The father then filed a motion for reconsideration, setting forth numerous cases, criminal cases, saying that, fundamental fairness dictates.
Well, that's the ramifications. What I'm trying to address is what was the explanation for being late?
I don't know that he had an explanation, Your Honor.
So why isn't that a problem?
I'm sorry?
Why isn't that a problem?
Well, I mean, it is a problem, and I'm not going to deny that. I mean, the fact that he was not able to fully articulate good cause and to say, I filed late, I forgot, I didn't get child's and department's expert information until past the deadline. Unfortunately, none of that was articulated. But I would suggest to this court that the judge has to go beyond that.
I mean, it seems to me normally a claim like this would be brought as ineffectiveness. My counsel was ineffective for not filing the witness list in the proper time, but of course then you'd have to show prejudice. And it seems like you're just trying to make an end run around showing prejudice from the exclusion of the witnesses. What am I missing?
Well, I think the father was articulating, and I think there were two witnesses in general that he pinpointed. One was CASA, and one was his own therapist. So I think there certainly can be inferences drawn that those witnesses would have been critical to the father's case.
Well, we have a report from the CASA person, which doesn't seem very favorable to your client. And the therapist, the judge actually goes through what your therapist said because the records were in and explains what the judge took from that. So what's different if they testify live?
Well, there's only one entry with the therapist. So that entry comes in August of 2023, and that's it. So there's no further discussion, no further mention of father with respect to those particular records. So father would be entitled, as he testified, that he was seeing that therapist consistently, and I believe at that point twice a week, to have that therapist testify as to his engagement, and again, to rebut the department's allegations that he was not able to properly raise this child. As far as CASA, the reports are not favorable to father. There is no doubt about that. Father is certainly entitled to explore any type of bias or any type of qualifications that CASA may have. Again, there's recommendations in those reports, and there's facts that father has or should have the ability to refute. Those reports are damaging. Father's inability to not put on this case.
Where in the record will we find that there was evidence of bias or lack of qualifications that could have been elicited if the witness had been called?
Well, I think that's fair game in any type of case, Your Honor.
It's fair game if there's something you can elicit. What could you have elicited?
We don't have that information, and that's part of the issue. And then, unfortunately, it affected father even further, because what the judge then did was he then shifted the burden back to father on page 26 of the record appendix in the findings, basically saying that father was unable to show current fitness or provide any evidence regarding his mental health diagnosis, treatment, or participation. And the judge then went on to find those failings of father as grievous shortcomings. All going back to the issue of whether or not father should have been able to produce any witnesses or have any witnesses testify. Certainly there were a lot less egregious sanctions, a lot more proportional sanctions, which the judge didn't even consider. It
But
was
we agree, we review for abuse of discretion, right?
correct.
So I hear you that other sanctions were available, and it may be that a different judge would have considered other sanctions, but as we look at it, what we're looking at is what this judge did, and was it an abuse of discretion or a clear error of law for him to make the ruling he made. And the challenge you have is that not only his counsel, but also your client signed a pretrial conference order that had a date for filing a witness list, and that included a provision that failure to comply with the provisions of this order shall be grounds for imposition of appropriate sanctions, including evidentiary restrictions. So sometimes a due process argument is based on notice, right? Well, I had no idea this was going to happen. But that's not, the signing of this document has taken that away for your client.
Well, I think that, Your Honor, you raise a good point in referencing that particular section. The verbiage is appropriate sanctions, and that's certainly what I'm arguing, that there were appropriate sanctions, but a wholesale exclusion of all the witnesses just isn't that, where you have such a substantive and substantial due process right in these cases. It's a parent losing their child. And to have that rest on the fact that a pretrial memo was 40 days late while the trial was still ongoing and continued for another month and a half, that's a clear error of law, and that's an abuse of discretion.
What is the best case you have for the proposition that that was a clear error of law? You have a similar case for us?
So I think there are several. I think the Brantley case is one, and I do cite all of these in my brief or reply. I think guardianship of Brandon. I think the GTE case, and
That's
I
probably
think
enough.
Yvonne, in the sense that this isn't just a regrettable due process violation. This is a complete breakdown of due process. So, again, I think that this judge needed to go beyond, and any judge does, to examine whether or not there was actual prejudice. The department nor the child could articulate that there was any prejudice to them. It was, you didn't file it, you're cut off. That's it. That was their argument. What was the harm to the department? What was the harm to the child? There was none. Everybody knew these witnesses. Some of the records were already in. The exclusion of evidence in any type of trial is so that the parties can receive a fair trial, not that they lose the right to a fair trial. Father refutes that he had not made gains, and father had the right to refute that. And these witnesses, even if they were limited in scope or duration, would have been able to assist in father's ability to advocate for his position.
How do we know that?
The fact that they, again, because we're missing information. So the judge is relying on the fact that father has not had any treatment or understanding of his mental health or his mental health diagnosis, and we have one entry in the records.
But how do we know that these witnesses would have testified favorably towards your client and filled those gaps?
Well, we don't know that, Your Honor, because we don't have that information. That the inability of father to bring forward those witnesses completely prevented that. and I understand, well, an offer of proof is certainly preferential. It's not required where the judge has wholesale excluded evidence. And that's the Lech-Daniels case that I cite in my reply brief. So if there are no further questions, then I would rest on the remainder of my...
Thank you. Mr. McChrist.
May it please the court, Aaron McChrist on behalf of DCF. I'll start with Father's principal argument that it was a procedural error to exclude the witness testimony that he sought to offer, and I'll explain why it's not error in a moment, but I want to start by highlighting that what is missing from Father's briefing and from the argument that was just presented is any explanation that the testimony he wanted to offer would have changed the outcome in this case, and that's in two senses. In one sense, there's a failure to make that showing because there was overwhelming evidence of unfitness. This was a fairly...
That's a good place to interrupt. So I understand that. And did the department affirmatively oppose his ability to call any witnesses, or did the judge decide that was the appropriate sanction?
When he tried to call his first witness, DCF did object because the witness had not been properly disclosed. So
with the overwhelming evidence of unfitness, as you share with us, what was the harm to the department letting the father call the witnesses?
Well, there was prejudice to the department and to the child in a few ways. One is these witnesses, the 33 witnesses that were on Father's witness list, were disclosed over 40 days after the pretrial memorandum would be.
But these two witnesses were witnesses you were aware of, right?
Aware of their existence, but not aware, well,
one of them was the CASA guy, and the other was the therapist who your investigator had talked to, right? I mean, you had done your work on these witnesses, these particular witnesses.
That's correct, Your Honor, although there were at least three things that I think DCF would likely have done if it had known about those witnesses. One is perhaps filed certain motions in limine. I believe that Father's late pretrial memorandum was filed on or about the date that motions in limine were due. The second is recalibrate its own case in chief potentially, depending on what it thought about Father's witnesses. I mean, the purpose of these disclosures ahead of all the testimony isn't just that we're going to be prepared to examine the witnesses on the day they show up for the hearing, but that so that the DCF and the child can make sure they are offering appropriate evidence during their case in chief to address witnesses they anticipate. The third is the opportunity to prepare cross-examinations for those witnesses, which they were simply shorted the amount of time that they ideally would have been given.
They were on, I just want to make sure I have the facts right. Both of the witnesses we're talking about were on the department's witness list. Is that correct?
That's correct, Your Honor. From Father's...
So to the extent due process addresses surprise, that is not an argument that is available to the department.
Your Honor, just to make sure I understand your question, you're asking whether the department could have made a due process argument about the late disclosure?
Yes.
Your Honor, I'm not sure whether they could have made a due process argument, although that's not really the argument that they were making. The argument they were making is that calling the witnesses was procedurally improper under the trial court's pretrial order and under Rule 15, and that argument was well-founded.
But those things, that was really bad, indefinite antecedent. But the pretrial order and the process are designed with due process in mind, right? For a trial to be fair in our system, people ought to know who's coming in, what's going to happen, right? So that's why there's a witness list, there's an exhibit list, there's often a requirement that the parties discuss those things and come up with what they agree and don't agree on. And that's all grounded in the fact that as a system, we believe that surprise should not be part of the courtroom experience. So to the extent that Rule 15 talks about not showing up with somebody, out of left field, the surprise witness, that was not an issue with respect to these two witnesses. DCF might not have been or wasn't on notice that the father intended to call these witnesses, but it's not a situation where DCF was unaware that these were relevant, pertinent witnesses with information that might be part of the trial.
Your Honor, I'm going to do my best to answer that question.
That was a terrible
two
question.
parts. No, you're right. I think I understand the question. I just want to make sure I'm answering it fully.
Awfully long.
Yeah, meant too many parts.
First response, just to clarify my prior answer, Your Honor, it is true to some extent that Rule 15 and that the pretrial order are aimed at furthering the same interests as due process in the constitutional sense. But those are two different mechanisms aimed at the same goals. Due process in the constitutional sense sets some floor or a bare minimum that the parties are afforded. We're not arguing that, or DCF did not raise a due process argument. But of course, there may be other mechanisms, including procedural rules and court orders that aim at ensuring that there's no surprise. And in that sense, DCF was taken by surprise that father wanted to call these witnesses, or at least at the time they received his late filed memorandum. And it is true that they couldn't argue that they were surprised about the potential relevance of these witnesses in some broader sense, but not that father would be offering them to testify at trial. Circling back to the point that father hasn't made a showing that the testimony of these witnesses would have made a difference in this case, there was overwhelming evidence of unfitness here. DCF was involved with father for almost a decade, and throughout that entire period, there was substantial evidence of mental health problems on father's part, and his mental health seemed to decline significantly throughout that period, not get better. In 2021, and I'll add for context, at least 4 different people took out harassment order and or abuse prevention orders against father. And in 2021, he was arrested and incarcerated briefly for violating those orders by making threats against Mr. D, who's referenced throughout the briefing. When he was released after his incarceration, on that very same day that he was released, he attempted to purchase a firearm to exact revenge on Mr. D and was arrested again that same day. At the time he was arrested, he was spitting at the police officers, swearing, and then was incarcerated again for 10 days. And this all precedes the incident that's discussed in the briefing where he encouraged protests at DCF's offices, where they had to close for a day because he had made posts online saying things like it's hunting season, which raised serious safety concerns about DCF's personnel. And he was arrested again in 2022, again for violating court orders related to threats that he made on social media about the child's therapist and DCF personnel. Your Honors, and then in the second sense, that father fails to show that these witnesses would have made the difference. As the questions during father's argument highlighted, there simply is no record to show that the testimony these witnesses had to offer would have even been favorable to him. The very first witness that he wanted to call was the CASA, who, according to all the evidence that's in the record, did not have positive things to say about father or his parenting. And by the time father was given the opportunity to file a motion for reconsideration, father had chances that he could have tried to make a record of what testimony those witnesses would have offered. Father did not submit affidavits from those witnesses saying, if we were given the opportunity to testify, we would say X, Y, Z, and for those reasons, that testimony would have been favorable to father. Instead, he submitted a very short memorandum, which didn't really make any showing or make even an offer of proof of what they were going to say. On that, I see that my time is concluded.
Your time is up. Thank you. Ms. Quiroz.
Good morning. May it please the court, my name is Christine Hamilton Quiroz. I represent the Applee child. I'd just like to start by saying that due process rights in these cases is very important. It's probably the most important piece of any care and protection case. I'm not here saying that father wasn't entitled to due process. He most certainly was entitled to due process. In this case, he was afforded due process. This judge gave him time and time and time again, attempted to even kind of give assistance to the attorney, but it's not the court's role to do the trial attorney's job. And he did have a lot of opportunity to rebut the department's case. He did have a meaningful right to rebut his case. I'd like to just start.
What was his opportunity?
I'm sorry?
You said he had an opportunity to rebut the DCF case. What was that?
He absolutely did. So he was represented by very good counsel. He had multiple opportunities to file motions in limine on the notes, on all the reports. The judge even asked several times of the attorney, do you want these coming in? Did you do a motion in limine? He even asked this specific trial attorney. He had an opportunity to make appropriate objections, which he did at times make appropriate objections. When some of those motions in limine came up, the judge even gave him time, gave him extra time to file them if he chose to do so. When it came to the two specific witnesses that he tried to call, the judge again gave him multiple opportunities to address why the judge should allow the witnesses to come in. He didn't do that. First, when he tried to call the witnesses, the judge went into a back and forth exchange. Give me a reason. Why should I allow it? Why didn't you file your witness and exhibit list on time? And to be clear, I'm not saying that he's not entitled to due process just because he missed a deadline. He's still entitled to due process. But the judge, giving him a chance to explain why, he gave no reason. He didn't say, I was unaware of this or unaware of that. He didn't provide an offer of proof. An offer of proof is essential in these cases. And where counsel brings up custody of Brandon, guardianship of Brandon, Brandon actually says that the court also has a duty to keep the trial moving and not to allow repetitive evidence. And where he missed the deadline by a month after the child had already testified, this judge was concerned that this was a legal strategy, and he wasn't going to hold up the trial or allow witnesses to come in and repeat evidence when there was really no reason to do that. He gave him, so after that first opportunity to explain why he should allow him to call the witnesses, the judge said, I'll give you some time. File a motion, file a single justice. I think it was 20 days later they came back. There was a motion for reconsideration, no offer of proof. He didn't say what those witnesses were to testify to, why he needed them. Mentioning due process is a start, but it falls far short of what is needed to show the judge that I actually need these witnesses because I'm going to be prejudiced in this way. He didn't do that. And he didn't actually say, on appeal he says that he wanted to rebut the testimony, but he didn't say that at any point during the trial. What he said was he wanted to question Dr. Kaplan on her notes. Her notes, they're very favorable, for the most part, to father. It's basically a regurgitation of everything that he said, excuse me, in court during his testimony, to court investigators, to GALs, to DCF. It's a repeat of things that father has accused the department of throughout the whole case. It would have been repetitive evidence. And the judge had he had nothing else to go on. This judge, even after the motion was filed, and he was heard on the motion, he argued the motion. And the judge asked him over and over, give me a reason. Why should I allow these witnesses? Is there new evidence? No. He didn't mention that he wanted the witnesses for rebuttal. He didn't clarify that. He just said, no, there's no new evidence. The judge here was within his discretion to exclude these witnesses when father had the burden to show that these witnesses were going to prejudice his case. He didn't do that. Under Paula, it's the appellant's burden. It's the appellant's burden to show prejudice, and he didn't do that. What counsel did claim was that the judge should have any and all evidence that could be garnered from their testimony, and that there's no harm. The judge isn't just looking at harm caused to DCF. He's also looking at, is this going to take up unnecessary time? Is this going to be a repetition of things that are already in evidence? And there was no indication that it would be anything other than a regurgitation of father's own testimony. Even if, when father didn't provide what he needed in that motion, and he didn't provide that information in the 2 times that he argued orally, the judge didn't make an immediate ruling. The judge seemed to understand that the witnesses really weren't for rebuttal. And on appeal, what father claims is that, for the first time on appeal, father claims that he was going to provide those witnesses would provide testimony to show that he had made gains with his anger management, understood the effects of it on child, and that the CASA would testify to positive visits, all of which was in the record already. There was some evidence about positive visits from CASA, but even if we exclude all of that evidence, the challenged evidence, and all of the reports and the notes, there's ample evidence left behind that comes nowhere near those notes. It's not included, it's not a part of the CASA reports. It comes in other places that father continually struggled to manage his anger. At trial, he testified that he understood that the child didn't want to go to some visits. He had made inappropriate statements to her during visits. She was afraid of visits. There needed to be a police detail at visits because of his explosions. He didn't understand why he needed anger management.
Okay, thank you. Thank you all. We'll take it under advisement. That'll
Thank you.
draw to a close today's lengthy list. I'd like to thank my colleagues, our court officers, our law clerks, the court clerk's office, and our excellent timekeeper. With that, I'm getting a note just in. That on it. Thank you. We'll stand at recess. We'll be out to speak to some guests shortly.
All rise.
I don't need to put that.